My name is Eirik Olav, and I'm here today to tell the story about a company in which I was the chairman and was on the board of directors for a few years. But before I do that, I'd just like to say a few words about why I'm doing this. I'm doing this not because I enjoy talking about what happened in Thule Drilling, nor am I very much interested in sharing private matters involving my family and my life. But I would like to tell the story anyway because it has changed me and my family in very adverse ways over the past 10 years. So my reason for being here is to tell my story about what happened in Thule Drilling and also how that has changed my life and my family's life over these past few years. Let me first say something about who I am. I am 60 years old. I was born in Helsinki, Finland. I moved to Norway when I was 3 years old and have basically lived in Norway since then. I have an education from the University of Georgia in the United States of America, a bachelor's degree in business, and I have a master's degree from the University of Miami with the focus on financing, international financing. I've worked in the shipping industry in Norway for a number of years, among others as a shipbroker, and I've also worked for one of the biggest shipping companies in the world, which is now called Wallenius Wilhelmsen. I have a background the last 15 years in private equity. I have been the manager for a private equity fund based abroad, and I've had the responsibility for all their investments in Norway and also in Scandinavia, mainly in the technology sector, investing some 450 million kroners in the technology sector, and also more financial investments where there was a fairly large portfolio at one time. Now, the Thule story for me begins in 2006. I was called up by one of the major shareholders, and I was invited to come into the board of directors in this company because the company had some challenges. These challenges concerned the building of 3 drilling rigs in the United Arab Emirates. In particular, it concerned the building or rebuilding of a total constructive loss of a drilling rig that had been on charter party to Saudi Aramco. Saudi Aramco is the largest oil company in the world and belongs indirectly to the Saudi royal family. Now, this rig was picked up by a Norwegian citizen shipping guy called Thule. He saw an opportunity at the time to buy that rig, find investors in Norway, rebuild the rig, and then get it on a charter. He started the company with his good friend, Henrik Christensen, who is a lawyer in the law firm of Ro Sommernes, and which law firm was later to become the liquidator for the Tula state. A giant conflict of interest, but nonetheless, that's what happened. I came into the board of directors in order to represent one of the other big shareholders, which was a private equity fund based abroad. Upon coming into the company, I realized that there were a lot of challenges that needed to be addressed rather quickly, and these challenges had to do with the building process. We were way behind in the schedules. Money was quickly running out of the company, and something needed to be done. So I was what you would call a devil's advocate in this board, and I quickly sat down and started to analyze what needed to be done. And after a while, to make a long story short, I was asked if I wanted to be the chairman of the company, which I became in the spring of 2007. Now, the challenges in building these rigs down in the United Arab Emirates escalated to the point where the people that were doing the rebuilding at the yard, who owned the yard, basically people from England, from Wales, and who had a long track record in that area, whereas Thule Drilling had no track record, they started pressuring us in order to get a higher price for their work. And this culminated on the 1st of July. During the night of 30th June, morning of 1st of July 2007, they dumped 2 big cement blocks in front of the yard, in front of the gates, and they basically had decided to hold us ransom. At that time, the drilling rig Tula Power was nearing completion, only a few months away from being finished, completed, and we had a 4-year charter party to Saudi Aramco. In other words, the Saudis were taking back on charter for 3 years a rig that they had previously used for an extended period of time. Now, when they closed down the yard, we were in a situation where we had no presence in the United Arab Emirates. We had not established a company. We were working through Noble Denton, who was the engineer that was doing the job for us down there. And we basically had no presence, which is crucial in the United Arab Emirates. You need what you call a sponsor, a local sponsor. that can help you and can also help you in situations like this. So while we thought that, you know, our contract was clear, they couldn't stop work, they couldn't hold us ransom. So we thought that by just using our lawyers down there that we could easily have the yard open, and we could in fact, according to the contract, take full charge of building the rig and complete it. As it turned out, there is no injunction relief in the United Arab Emirates, which meant that we had a long way to go in order to actually get into the yard. When this became clear to us and our lawyers told us that it might take as much as 4, 5, 6 years to actually win this battle in court, we understood that we had serious problems. Now, at that point, I was the chairman. The administration in the company, the daily operating people in the company and the other board directors, they looked at me and they said, so what are we going to do about it? And all of a sudden I felt a heavy burden of trying to resolve this situation somehow. As luck would have it, I had previously, a few months before they closed the gates, I had contacted a friend of mine, also a previous business partner, called Ron Lecars, an American citizen. And I had discussed this with the board to have someone come in from the outside and look at the various tasks that we needed to complete at the yard in order to get things back on track with respect to completing the rigs. Now, Mr. Lecars had only been in Sharjah for about, I'd say, 2-3 weeks when this happened, or at least he was given the job 2-3 weeks, maybe a month before. And when he came to Sharjah, his immediate job was then to knock on every door down there to see if we could resolve the situation, get these guys to open the yard so that we could complete the rig. At that time, the penalty, the daily penalty associated with the contract to Saudi Aramco was costing us close to $100,000 a day. So every day that this yard was closed, we were losing money. And obviously, if this situation continued for a long time, we would be in a situation where the liquidity in the company would be drained, and no investors, not the existing shareholders, nor the bondholders, the creditors, would be willing to support the company with further liquidity. So we had a very short time to try to resolve this situation. Now, I was chairman and I took responsibility for that. And what I did was tell the cars that we needed to go knock on every door, try to find someone that could become our sponsor and help us out of this situation. What happened over a few months was that Lecars, who had previous good contacts inside Saudi Arabia, managed to get the royal family in Saudi Arabia involved in this situation. Specifically, he was talking to representatives of the royal family, in particular representatives of Daran Oil and also a company called Advanced Business for Modern Technology. These two companies are owned by His Royal Highness Prince Michal, who used to be the defense minister at one time for Saudi Arabia, and his son, His Royal Highness Prince Michal. I have never met these people myself. All contacts were carried out by Mr. Lekars. However, he got these people involved, and as I said, they had at least an indirect interest in getting involved because the rig was chartered out to Saudi Aramco. So what happened was that through various discussions with Mr. Lekars, His Royal Highness Prince Michal went to Sharjah. He sat down with the ruler of Sharjah. They have close connections because of the long-lasting relationship between that emirate, that particular emirate, and the Saudi ruling family. Now we have documentation regarding this that shows that His Royal Highness was in meetings with the ruler of Sharjah, and the documentation shows that they took a keen interest to help Tula, to actually relieve the situation, make sure that the courts in Sharjah handled the case expediently, but within the law. At no point were there any question about paying for extra services or doing something corrupt. It was simply meant to be that we should ensure that these, what we consider to be criminal elements that had closed down the yard and were blackmailing us for money, that they were not able to sort of procrastinate the situation, extend court hearings, and do everything that could possibly be done to delay us getting back into the yard. Now, we had some success in the courts in this process, and gradually throughout the fall of 2007, we managed to get court hearings that ruled in our favor. These were small victories, but nonetheless, we were able to get into the yard to do some maintenance on the rigs, which was crucial because you're in a place where you have extreme warm weather, up to 50 degrees Celsius, and you also have a lot of sand. So if you leave a rig lying still without maintenance, very soon things deteriorate. So that was extremely important for us, and we managed to get that done. Now, during the early fall of 2007, we discussed in the board of Thule Drilling that we really had a big problem concerning the charter party to Saudi Aramco. The penalty clause for late delivery was structured so that every day that we went beyond the delivery date, they could deduct 75%, a certain percentage of the charter hire, and that would be deducted from what they would be paying over the 3 years that we had the rig on. So as a matter of fact, by December, end of December 2007, that penalty would be $22 million. It increased by $2.2 million per month until we could deliver the rig. Now, because the rig was unavailable to us, because we were being blackmailed, we couldn't get into the yard, we knew for a fact that we would never be able to deliver the rig by the end of February 2008. That was an impossibility. At best, we could, and if we were let back into the yard full time, we could probably maybe deliver the rig by the end of 2008. In other words, we were in a situation where by the time that we could deliver the rig at the earliest possible hopeful date, we would have losses amounting to 40, 50, 60 million dollars in that neighborhood. And so without resolving the situation concerning the charter party, without getting into the yard, this was a dead company. We knew that. So our primary concern was, number one, we have to get into the yard. Somehow we have to go to Saudi Aramco and try to get them to cancel or renegotiate the charter party in order to avoid these penalties, because it was killing the company. And we knew that if we weren't able to do these two things, and in addition to that, make sure that we were not blacklisted by Saudi Aramco, because that happens if you can't deliver a rig on time. If we could accomplish those three things, then we knew that our chances of having our existing shareholders, our creditors, and maybe new investors come in with more money for the company, so that we had operational money in order to complete the rigs. Now, this situation with Saudi Aramco was very delicate. I mean, there was nothing positive for Saudi Aramco in renegotiating this charter party. In fact, they could sit still and wait until we delivered the rig. And if we delivered that rig after 3 years, they would have a free rig. They wouldn't have to pay anything for it. So obviously it was not in their interest for us to cancel or renegotiate anything. So we decided that we had to use Mr. Lecar's contacts in Saudi Arabia to try to get the first family and the real owners of Saudi Aramco to help us. In other words, do us a favor and talk to the the operational management of Saudi Aramco. So what happened was that Lecar's, on our behalf, went there, and he talked to representatives of both Saudi Aramco and the royal family. And miraculously, they agreed to cancel this charter party. And that was done at the end of November 2007. They announced that they would be doing so. And then in accordance with the contract, a little more than a month later, I think it was in beginning of January 2008, that's what they did. Now, as a result of having the charter party canceled, we obviously were in a position where we could tell the investors that money is now no longer being drained out of the company. We will be able to renegotiate at a later date with Saudi Aramco. We are not blacklisted, and we are then in a position to get back into the yard, at least partially. In other words, we had resolved the main issues for going to our existing shareholders, our creditors, in order to find further finance for the company. At this stage, at the end of 2007, beginning of 2008, The cash situation in the company was that we had about $5.5 million in the company's accounts. We had short-term liabilities, that is liabilities that fall due within the next 12 months, of about, I believe it was about a little more than $200 million. So we had short-term liabilities of over $200 million and $5.5 million in the accounts, and we were way behind on operational expenditures that were falling due. So in other words, this situation that was resolved meant that we could go to our shareholders, we could go to our creditors, we could tell them that we'd resolve this situation, and in fact give them an incentive to further finance the company, which is exactly what we did. We have documentation to the effect that shareholders, creditors who had basically given up on us when they heard this news about canceling this charter party, getting access to the rig and so forth, came back to us and said, we're ready to put in more money. So in other words, we avoided bankruptcy. The company would have gone bankrupt early 2008 if we had not resolved these three issues. That is getting access to the rigs, at least partially, getting this charter party canceled, which was draining the liquidity of the company, and also avoiding being blacklisted by Saudi Aramco. So we accomplished all these three things. I was the one who was, working with the various people that were trying to get this accomplished. I went to bed at night with these problems. I got up in the morning with them, and I worked relentlessly all this time in order to make that happen. After it happened, people came up to me and congratulated me and Tula on a job they never thought we could have accomplished. So, in other words, we were able to get more money into the company. In connection with doing this, I was approached by Mr. Lecars, who said that the people that have helped us, they wanted some kind of fee. We knew that, of course. That was relayed to us fairly early on in the process, that if they were able to help us, they would want some kind of fee or some kind of remuneration for doing so. And Mr. Lecars told me that basically they thought they'd saved the company from going bankrupt, and the initial proposal was that they should get half of the company for basically nothing. And I told Mr. Lecars that I could never bring that to the General Assembly. I could never bring that to the shareholders in Tula, because they would simply laugh at me for something that they would consider an outrageous fee. So I told Lecars that he should talk to the largest shareholder in the company, and they should agree, because I felt I was too close to the Saudis through Mr. Lecars. It ended up that they agreed to pay a fee of $6 million to the Saudi people who helped Tula in this situation. And subsequently, this money was paid out. Now, everyone was very pleased with having paid this money out, with having resolved the situation, and Tula was able to at least partially start rebuilding or building the rigs. And for other reasons, through 2008 and 2009, where we got into trouble with the creditors who wanted basically to take over more and more of the company, it ended up in a situation that eventually bankrupted Tula in 2010, September 2010. That was because of events that had nothing to do with the rescue operation in 2007, 2008. That was because of different scenarios, different problems having to deal with the creditors' wish to take over the company. I resigned as chairman 1 year before the company went bankrupt because I was uncomfortable about the power struggle that was going on. And I decided to leave the company because I felt that I was surrounded by basically greedy people who were unable and unwilling to sit down and find a solution that was good for everyone. And at one point I decided they'll have to deal with it themselves. I'm pulling out, and I did. Now, as the story would have it, Tore Enger, who started the company together with his friend Henrik Christensen, they had agreements in place that was detrimental to the company. This I found out shortly after I became a member of the board. This is back in prior to the events I've just talked about. And they had certain agreements about options to be built, option for building additional rigs and so forth, in which they had a commercial interest. And I thought that these commercial interests were detrimental to the company, to its shareholders and creditors. And I was a very strong advocate in the board meetings to have these agreements cancelled, because I thought that the board would be responsible to its shareholders and its creditors if Mr. Enger and Mr. Christensen, who was also then a self-appointed lawyer through his company, if these agreements were carried out, they would be to their self-interest and to the detriment of the company. And we had serious arguments about this, of course. The other board members, they wanted to find an amicable solution and tried to get me to agree to some sort of compensation for Mr. Enger in connection with these options, these fee arrangements. And Mr. Henrik Christensen, the lawyer who helped establish the company and who was a friend of Mr. Enger, also tried to persuade me that I should give him something, or that the board should give. I was relentless in this, and I said that we cannot, our ambition was to become a publicly listed company. I said we cannot be a publicly listed company and have these sort of deal within the deal. And finally, we found out that Mr. Enger was using blueprints from Thule Drilling of our rigs, taking those out of the company, going to a yard in Canada, and actually bidding on projects in competition with our rigs in Thule Drilling towards, among others, Saudi Aramco. Well, that was the final straw for the other board members. They realized we couldn't have that person on the board of Thule Drilling. And we asked him to resign himself so we wouldn't have to kick him out. Of course, this was a big concern for Mr. Christensen, who, besides being a good friend and the godfather of one of Tore Enger's children, felt that I had been too tough. But I finally got the support I needed from the other board members to kick Tore Enger out. This created a situation where relationships with Henrik Christensen also became very strained. And I wouldn't say that it was a power struggle, but at some point Mr. Christensen decided to step out. At that time, the thing to keep in mind when I'm talking about Tore Enger, the founder of the company, and Henrik Christensen and their close relationship and their demise or leaving Thule Drilling at a certain juncture in 2007 and me taking over as chairman, is that it was basically because of actions that I took in order to sort of clean up the house and make sure that we were doing things in accordance with what I consider to be, good management of shareholder and creditor values. That was my main concern. In doing so, I probably upset a private agenda by Mr. Thule, and I suspect also his good friend, Mr. Henrik Christensen, to use Tula not only as a vehicle for going public and increasing shareholder value, and also servicing the loans to creditors in the appropriate way, but also to enrich themselves during this process. They had a keen interest in going public as quickly as possible. They also held warrants in the company that they wanted to exercise. Substantial number of warrants, which is the same as options really, at a certain price. And their main concern, in my estimation at least, was to make a quick buck, make as much money as they could, get out, let everybody else be stuck with the rather large challenges in getting these rigs completed. We were way behind schedule, and there was major cleanup work to be done. But these two gentlemen, they were more interested in the immediate profits that they could reap in a very good rig market. Investors were running over themselves in order to buy shares and get into various rig companies. It was a very hot topic at that time. So by me sort of indirectly or directly stopping their own personal plans for making a quick buck obviously left me in a position where I was not well liked by these two people, and I think in particular Henrik Christensen. Now, this situation with Henrik Christensen escalated because we had previously entered into a bondholder agreement with Norwegian and international bondholders, some of which were large American hedge funds. And they had financed a large part of the company. This amount that I mentioned previously, with about $200 million outstanding in debt, short-term debt, that refers to these bond loans. Now, in connection with an agreement we did with the owners down at this yard in Sharjah, called the QGM yard, when they ran out of money, we had to fund them. And so we used part of the bondholder loans that we got to extend a loan to these owners of the yard for about $22 million. In connection with that, we wanted to have a security package. I mean, a security package would be like a mortgage or other forms of security that would ensure us that we would get our money back. We also had an incentive package for them if they were able to complete the rigs quicker than they thought they could. Now, in this connection with this, Mr. Christensen was involved, not on a full-time basis, but he was the chairman of Tula. He was also a self-appointed lawyer for Tula, using his and other lawyers' services in his own lawyer firm, Ro Sommernes, using his partners to make money out of Tula as a sort of house lawyer for Tula. I found out after some time that he was charging for every minute he spent working on Tula. Even telephone conversations with Mr. Thule, where I'm sure they didn't only talk about Tula, but they talked about private matters and family matters. But Mr. Christensen was very good at sending invoices, and over a period of some months or a year, I think the invoices ran up to in excess of 1 million kroner easily. Now, I was not happy about that, and I started looking into these invoices after Mr. Christensen had left the company. And I found out that he'd charged money in an invoice saying that he had actually looked at the security package for this loan with QGM. And that security package turned out to be very, very bad, because it did not stop these guys from stealing the shares in the company and actually paving the way for them being able to close the yard. So the job was a very, very bad job. And I confronted Mr. Christensen, and he denied having worked on the security package. I showed him the invoice where it said that he had. I asked him, did you work on it, or did you do a bad job, or are you lying and you did in fact not work on it? Well, I never got an answer. And this prompted me to have our lawyers in Tula, our new lawyer, go to Rolf Sommernes and demand to get all of Christensen's documents dealing with his time in Tula. I wanted a copy of everything to make sure that he had actually done what he was supposed to do as chairman of the company and more or less self-appointed lawyer for Tula. And when I asked for this through our lawyers, Christensen and his partners in Rolf Sommernes said absolutely not. You will never see this. First they said that you won't get it. When I insisted, they said that Mr. Christensen had a crash on his computer, that unfortunately the information was not there anymore. Then they understood that that explanation was not good enough of a lie, and they told me that Mr. Christensen had erased everything from his computer that was more than 4 months old. Now, everybody knows who works as a lawyer in Norway that you are required by law to keep your files for at least 10 years. Now, we had to go to the courts in order to force Mr. Christensen to give us documents that I could look through to see exactly what his role had been as a chairman and as a board member in Tula. And Rolf Sommernes were able to stop us from this. I still don't know why the court would not let us see papers that were actually, in the legal term, the ownership of Tula. I mean, any kind of document that Christensen were doing on behalf of Tula during his tenure as chairman belongs to the company. Yet somehow they managed to convince the court that we could not get these documents. So at that time, we were having other serious problems in Tula, which I've told about before, closing of the yard. So I had no chance to pursue this further through the courts. I had to concentrate on the problems at the yard, the cancellation of the Saudi Aramco charter party, and such things. But obviously, there were heated discussions, and it didn't make my relationship to Rolf Sommernes and Henrik Christensen any better. And the reason I'm telling you this is because, as we shall see, when Tula in 2010 filed for bankruptcy for none of the reasons I'm talking about here. For some strange reason, Ro Sommernes were allowed to become the liquidator for the estate. By becoming liquidator for the estate of Tula, we had gone full circle. They were now in a situation where they could dictate, as the liquidator, what information should be shown to the public and what should not, which meant that information about Christensen's role in the company, when he was the chairman and on the board, would actually be in the full control of Ro Sommernes and his partners. In other words, they could decide whether any kind of request from me or others would be allowed, so to speak. They were in full control. Now you might ask, why would a court allow Ro Sommernes to become a liquidator in a situation where they had such previous experience and financial interests, and also interest in not disclosing information to Tula and to the public? Well, that is a question that is unanswered today, and it's a question I still would like to have an answer to. However, the courts in Norway will not allow me to get that question answered. Now, after we had, going back a little bit in time, we managed to get the funding in from the investors in early 2008, and we struggled with the opening of the yard, and it became clear that having managed to cancel the charter party to Saudi Aramco was the best thing that could ever happen to Thule Drilling, because there was delay upon delay. The courts, the cases in the various courts in Sharjah were delayed, and it turned out that Thule Drilling would never have been able to deliver Thule Power until way out in 2009. As it turned out, and for other reasons, it was never delivered. At one point, we were only a couple of months from being able to deliver the rig, back in 2008, 2009. However, the rig, to my knowledge, is still lying there in 2016. That's 8 years later. It's lying there, it's rusting, and it's never been delivered. According to my information, the rig has been sold via third-party people and companies through companies in Switzerland, perhaps also through some Chinese connections, and the end destination is Iran. So in other words, the liquidator for the Tula state more than likely has full knowledge and has willingly sold Thule Power against United States anti-terrorist regulations, so-called OFAC rules. However, I have not been able to document this, but I have sufficient documentations to say that that is very likely what has happened. Now, anyway, what happened in Tula later on, after I left as chairman, for other reasons than the rescue operation and this, Tula eventually went bankrupt. And the first thing that happened after bankruptcy, proceedings were opened, and Ro Sommernes, with Mr. Sommernes himself in charge, being liquidator of the Tula estate, summoned me in as the former chairman to talk about my knowledge of what had happened in Tula. I went to 2 meetings, both of which Peter Jessing, the former chief executive officer of Tula, also attended. And those 2 meetings lasted about 3 hours each. And in those meetings, we decided to put our differences aside, and I was very open with them about what had happened in Tula. I told him about the Saudi connection. I went into detail about how we discussed how we could save the company from going bankrupt, and very openly. And I was very surprised after having been that open with him, telling him about how we got the charter party canceled and how we got investors in, that in the beginning of 2011, I believe it was 2011, Mr. Sommernes filed a lawsuit against me for having paid these $6 million, or not me personally, but for the company having paid these $6 million in fees to the Saudis. He knew very well that who they were. He knew who they represented. He knew that everything had been done according to the book. He knew that there had been a due diligence process by Nordic trustee, that's Norsk Tillitsmann, during 2008. That had concluded who the real helpers of Tula were, who actually were getting the proceeds of these $6 million. And this was done by a law firm in Singapore with a presence in Dubai. They came back with the conclusion that what we had done was absolutely correct, that the people that where the recipients of this $6 million were actually those that have helped the company, namely the representatives of the royal family in Saudi. And still, he filed a complaint or a lawsuit. Now, the reason why he did that is fairly obvious, because I'd been very critical of the liquidation process up to that point in time. I felt that the liquidator were not interested in anything but to serve the interests of those who could actually pay their lawyer bills, which of course were the bondholders. These American hedge funds, they could pay the bill, they could foot the bill for Ro Sommernes. And if you're a liquidator for an estate and you're a lawyer who makes money from being a liquidator, you obviously want to serve those interests that pay the bills for you. And that's what they did. And I felt that they did this without question to what was correct according to the law. And I felt they did it without any thought of interest for the shareholders in Tula who had lost everything. So I was a very critical opponent of the way they handled the liquidating process. Now, you add to that my history of conflict with Mr. Christensen, who was a partner of Sommernes in Ro Sommernes. The situation became such that they probably felt that I was a hair in the soup. They didn't particularly like my involvement in trying to tell them how to run the liquidating estate, and if not how to run it, at least be so critical. And I suspect that was one of the reasons that they filed this thing against me. At this point in time, I was concerned with, as I said, I was concerned with the liquidator for the state doing the right thing for everyone, all the stakeholders. And this was when strange things started to happen. Ro Sommernes pulled back this lawsuit. They did not pursue it any further. However, as it turned out, they had instead turned around and filed a criminal complaint against myself, the largest shareholder and board member in the company, Mr. Anders Ivar Olsen, and against Peter Jessing, the CEO, for having paid this fee of $6 million. I remember, in particular, one day in May, where I was walking my dog. I usually take my dog for a walk in the woods around the Holmenkollen ski park. And this particular day, which was, I believe it was middle of May, I was with my dog in the woods when I was approached by two strangers, a man and a woman. I would say probably mid-40s. They stopped me and they started doing small talk about what a nice dog I had. I have a German Shepherd. And after small talk, they finally said, the man said, lady never said anything. The man said, you're Hans Olav, aren't you? I said, yes, I am. And they said, you were the chairman of Tula. Is that correct? I said, yes, I was. And then the guy said to me that, or the man said, I'd like to give you some advice, just friendly advice, and that is that you need to pull back. There's a lot of money at stake here, and your involvement in criticizing what the liquidator is doing is causing problems, and it's not appreciated. I'm not here to threaten you or anything like that. I just want to help you. I want you to know that it's probably not in your best interest to continue criticizing the liquidator. You should think long and hard about it and perhaps pull back and stay quiet. I asked him and the lady that was with him who they were talking on behalf of. I wanted to know who they represented. But he said that that's not important. The important thing is I'm trying to give you some good advice and you should listen to it. And I probed the question, but he would not answer. And as I said, the lady with him didn't say one word during the whole conversation. And finally they just clapped my dog a little bit, said some nice words about the dog, and then they left. Now, afterwards I felt that this was a very, very clear warning. Either you back off or something's going to happen to you. Now, less than a month later, the doorbell rings in our house, 7 o'clock in the morning. I go down, I open up, and outside is about 6 or 7 people. And they introduce themselves as officers of the criminal police in Norway. And they said that they're here with a warrant for my arrest. And that's the reason for this is a criminal complaint filed by Ro Sommernes sometime before that. I was followed upstairs. I asked if I could go upstairs and put some clothes on. And I was allowed to do that, of course. And they followed in my footsteps, as they said, to make sure that I didn't destroy any kind of evidence. Now, that was a bizarre question because all the evidence and all the documentation in Tula were already subject to civil litigation. So every document that you can conceive was out in the open. However, that's what he said. So after getting dressed, they took me into a car, and in front of my wife and children, they more or less dragged me out and put me in the car and took me down to their headquarters in order to be interrogated. Now, as I learned later, they treated my family very rudely while they were there. In particular, my daughter, my oldest daughter. I don't have to go into details about how they behaved, but they were very rude. So I get down to the station, and they tell me that I'm charged with misappropriation of funds for Tula, and that they need to talk to me about that. And they said they were going to start the taped recordings. At the beginning of this, they tell me that if you tell the truth right away, that will have an influence on what kind of a sentence you'll get. And I said, why are you telling me this? I haven't done anything wrong. In fact, I've done a lot of good things for Tula. And they said that, well, we just need to tell you this. And they started the tape recordings and started asking me questions. And after about half an hour, I understood that they knew really nothing about what had happened in Tula. They were on a fishing expedition. They simply wanted to have me tell the Tula story from beginning to end to see if there was something there that they could use against me. Why did I know that? Because their knowledge was clearly very, very little about what had gone on in Tula. And but I was being cooperative. I talked to them for a few hours, they were asking me questions. I answered as best as I could. And then we had a break. During the break, I had gotten a lawyer present to be there with me. And this lawyer, who was only a temporary lawyer, because I needed one there, he told me during a break around lunchtime that the story about the criminal police coming to my home, pulling us out of bed, taking me down to interrogations, which is really something that is not a public matter. They're not supposed to, make that official, go to the news media, whatever. But I learned in this short intermission from this lawyer that the story about me being arrested was actually published before they came to my house. So they had leaked to the press about this. And it was all over the press that I was being arrested, I was being charged with this and that. And the only source for this information coming out was the criminal police. So I thought about this a little bit, and I went back into the interrogation room, and they asked me if I was ready to talk some more. And I said, sure. So they turned on the tape recorder, and I said, before we start, I'd like to say something. And the detective said, well, I'll just turn off the tape recorder. And I said, no, leave it on. This needs to be told, and it needs to be on tape. And I told him that you come to my house, you drag me out of bed, you treat my family like dirt, basically. You bring me down here. You obviously know nothing about Tula, very little. You start asking me questions like I'm some kind of criminal. And you tell me that you're doing all of this because you want to build respect. You want to build a relationship so that we can get to the bottom of what happened in Tula. At the same time, you leak to the press, even before you came to get me. You leak in a very, very private matter that you're not supposed to leak. You tell the press that we've pulled him in. You managed to get me on the front page of every newspaper. And that's a breach of your duties as, criminal investigators. You're not supposed to do that. Yet, still you tell me that we're supposed to build respect because you just want to talk to me and find the truth. Well, how can I respect you when you treat me like this? Respect in my book is mutual respect. You have to build respect and not tear it down. And you have shown me these first 3 hours that you actually know nothing about what happened in Tula. You're obviously on a fishing expedition, and you have absolutely no respect for me. So why should I have respect for you? So this interview is over. I'm not going to talk to you ever again. Because if I can't speak to people where I have mutual respect, I don't want to talk to them. So you continue with your fishing expedition on your own. I'm not interested in talking anymore to you. So at that time, they obviously had to respect that. They told me that that could work in your disfavor. I said, how can it work in my disfavor? How can people who are obviously trying to frame me for something, obviously on a fishing expedition, obviously have no respect for me, and I refuse to talk to them for those very reasons, how could that possibly hurt me? So after I told the criminal police that I would no longer talk to them about this case, until they actually made some conclusion as to what the charges might be, they took me back to a cell for the night. This was what you call a primitive cell, and a cell where they keep people very short periods of time, so-called stripped cell. And they put me in there, and they said that they would get back to me the next day. Now, in this stripped cell, I simply sat down and I stayed there for a few hours thinking about the events of the day. And then around 7 o'clock in the evening, I was summoned downstairs, and I met a lawyer, Jon Christian Elden, whom I had not asked for to represent me. I actually hadn't had the time to ask anybody to represent me. But he said that he was my lawyer. And I told him that I'm used to working very much on my own accord, and I'm sort of the kind of person that thinks that if you don't do things yourself, you can't make sure that they're actually done right, and that I wanted to represent myself because I had done nothing wrong, and I felt confident that I would be able to convince people in due course that I had actually done some very good things for Tula. And Mr. Eldon laughed a bit, and he said that only fools refuse to have lawyers in criminal cases. So I said, okay, I guess if you have been appointed my lawyer, I'll stick with you. He then went on to say that he'd read himself up on the case. A few months previously, I'd written a 4-page email to a lawyer in connection with the initial lawsuit filed by Little Sommernes about all the events that had happened in Tula. And Mr. Eldon said that he'd gotten a hold of this email. He'd read the email, and he said that I had nothing to worry about. This was at best case, a civil case. There was nothing illegal done whatsoever. I should relax. This case would go away very quickly. I had no reason to be scared at all. So on that notion, I went upstairs to the cell, and unfortunately I agreed by being persuaded by Mr. Eldon and his colleague in Eldon, the law firm of Eldon. I was convinced, or I was persuaded to talk to the criminal police the next day. A decision that I regret to this day, because the line of questioning was the same as it had been initially. They were not interested in getting to the truth. They were simply interested in trying to get something that they could make stick so that they could charge me with a crime. Now, one example of that was that they would ask a question about a certain document. I would tell them that this document I had not read for 4 years. They wanted me to get my opinion on why this document came about, such as, for example, the invoice filed in connection with the $6 million that was paid out. And I told them that this is a long time ago. I can't recall what my thoughts were, but I can tell you what my thoughts are now and how I would handle this situation now if it occurred now. And I would do exactly what I did then. And then I proceeded to explain to them how this transpired. Now, I thought that that explanation was clear, and I left it at that. And they would then continue to ask me all kinds of other questions of very little significance. But they would continually come back after 10 or 15 minutes. They come back to that original question and ask me to answer the question again for an obvious reason. Is this explanation different this time? And finally I told them, you're asking me the same question over and over again. I tell you it's too long ago for me to remember exactly, but hypothetically and theoretically, my answer would be this. Now, I've given you this answer over and over again. Why do you continue to ask me this question, if not for the simple reason that you're trying to find out if I'll answer it differently? And I said, please stop this line of questioning. You're not going to get a different answer. Well, anyway, after all was said and done, I was brought back to the cell, which again was a stripped down cell. A stripped down cell is a cell where they only keep you, or they're supposed to keep you, for a certain period of time. There are very strict rules set down by the European Human Rights Convention about how long you can keep a person or a prisoner in a stripped down cell. And as it turned out, they kept me there 2 days longer than the torture paragraph, as they call it, allows. And the reason was, of course, to soften me, try to get me to say something simply out of desperation to get out of that cell. So they did it on purpose. And in the court hearing concerning whether I should remain in jail for the next 14 days or for a month to give them time to investigate my case, and Mr. Elden, my lawyer, brought to the attention of the court that Mr. Olav had in fact been detained in a stripped down cell longer than torture paragraph allows, according to the European Human Rights Convention. The judge proceeded to reprimand the criminal police for having done so, and they all agreed that that was a shame, it shouldn't have happened, and they're going to make sure I didn't go back to that cell again. Well, of course, the exact opposite happened. They put me straight back in that cell and kept me there for another 24 hours. So I've gotten a relief from that, in as much as they admit that they've done it, and they've theoretically awarded me a few thousand kroner for having done so, which I've never collected. Now, after having been in that stripped down cell, Elden told me before the court hearing concerning whether they should be allowed to keep me in custody for another 14 days. He told me, this is how it's going to happen, Mr. Olav, because I've done this many times before. You will be allowed to say your piece in court, and you can tell them about evidence that they have precluded, which they should have put forward to the court. This is evidence that would have made the case completely different, but they avoided giving the whole picture to the court. You will be given a chance to state your case. What's going to happen then is that the judge is going to pretend that she's interested. They'll adjourn the meeting in the court. You'll be put back in your stripped down cell. This is a Friday, so the judge wants to go home as quickly as possible, but she has to pretend that she's actually doing her job. So what will happen is that 3-4 hours into the evening, she will come back with a verdict that you should be put into prison for another 14 days or a month to allow the criminal police to further investigate the case. Now, that is an illegal decision by her. She shouldn't be doing it, but she does it because they are so close, the criminal police and the first court, the first municipal court. They are so close with each other that they will cooperate in this. Now, I have here already an appeal that I will immediately submit to the court because I know what the verdict will be. This appeal will take a few days for the appeals court to look through and make a judgment on. And as you can tell, the timing of this is such that you are put in prison right before the weekend. So nothing will be done with this until Monday. It'll take 2-3 days, and then the Court of Appeals, they will come back and they will rule in your disfavor. In other words, that you should be in jail for the full 14 days. They will do this knowing that applicable law is being broken. They know that it's wrong, but they will do it because that's what they do. They work together. The criminal police and the court system work together in cases like this. I will then file, and I already have this ready, I will then file a petition to the Supreme Court calling for them to stop this travesty of justice and to let you out. The Supreme Court will have no other option because I have all the judgments pertaining to these kind of incidents, they will have no option but to call this imprisonment of you for 14 days completely illegal, and you will be let out. However, it will take the full 14 days. So in effect, you'll be in for 14 days, then you will win, then you will be let out, but in the meantime, you have to sit there and wait, in solitary, by yourself. Well, as it turned out, he was right. It happened exactly like he told me. After 13 days, verdict came back from the Supreme Court saying that this imprisonment was illegal, that I should be let out immediately. However, I wasn't told about that verdict the same day that it came in. Turned out that criminal police got this verdict one day, didn't execute it until the next day, because they wanted to have one last interrogation of me. So instead of allowing me out the way they should have, they rushed in their cars up to where I was sitting in prison, going through an interview with me for about 2 hours, and not telling me that in fact there was a court order for my release. So indirectly, they kept that from me and they lied. I kept asking them throughout the interview if I could please be allowed out the next day, because I was going to go to the graveyard in order to put the urn from my father in the ground. And I said, they'd previously told me that if I was going to go do something like that, they would allow it, but they would have police escort me. I said, then I don't want to do it. I don't want to disgrace the whole procedure by having policemen. Where could I run? Where would I run? I've done nothing wrong. Why won't you let me be part of my father's funeral, my burial? Well, turns out that they sat in this last interrogation meeting where I asked them, I pleaded with them, please, let me go put my father in the grave. They did not answer the question, knowing that there was already a court order for my release. All they said was to my lawyer, who was present, that we're going to call you from the car to tell you something. And what they told him was, of course, that I was free, that I could go. But instead of telling me that in the meeting when I was pleading with them, almost crying, to be able to go participate in my father's burial, they lied about it. So, 30 minutes after they left, I got a call from my lawyer saying that you're free to go. So I packed up my things, I called my wife, and said farewell to all the guards. I made some very good friends up there. And in fact, all of the guards that I had anything to do with during those days that I was up there in full solitary cell, all by myself, I got to know them fairly well. And they all lined up when I was leaving, even those who were not on duty. They heard that I was being released. And they shook hands with me and they said, we've read about your case, and we're rooting for you. We hope you win. So I left and I was picked up by my wife, and it was a real nice warm day, and in the car back she gave me a beer, came home, the rest of my family was there, my mother, and we hugged and we cried, and we talked about what had actually taken place. So after that, the criminal police contacted my lawyers. They wanted to interrogate me some more. They wanted me to come down to headquarters. And I told them absolutely not. I don't want to talk to people like you. And they threatened to have a court order. And I told Mr. Elton, my lawyer, that okay, get the court order, bring the handcuffs, put them on me, bring me down to the judge, And I'm going to tell the judge exactly what I think about you people. How I've been mistreated, disrespected, and how you have no interest whatsoever in finding out the truth. So finally, Mr. Eldon told me that he laughed a little bit about it, and he said that, never seen this before, but I think they've given up on you. They realize they're never going to get any word out of you. So they gave up in trying to interrogate me. Anyways, time passed by, and this was in the summer of 2011. I should say that in the weeks after I was released, I had a deep anxiety over what had happened. Only those people who have been in a stripped down cell for 6 days will know what I'm talking about. It's an experience, it's a life-setting experience. It really is something very, very special. And the lights never go off, not completely. There are lots of screaming, lots of people in there that inflict damage on themselves. And you sit there, you listen to this, and you watch the clock ticking. There's a clock on the wall, big clock. You watch the minutes and you watch the hours go slowly by. Anyways, I had a great anxiety when I came out, and would wake up in the middle of the night thinking that they're coming for me. And my wife and my friends told me that you need to relax, you need to calm down. You're out now, you shouldn't be worried. So gradually I let it go. I did not turn on my telephone for about 3 weeks. I did not go on my computer or send mail or anything for 3 weeks. And I was just really, I guess, very badly affected by all those events. Anyway, time passed by, things started normalizing, and this was 2011, August, July, August. I asked my lawyer, what happens now? He said, well, they're going to spend some time looking into matters. And that meant that nothing happened in my case from August 2011 until the spring of 2013. So almost 2 years later, I decided I hadn't heard anything from them. They were looking into matters, that's what I heard. And in the meantime, my life was on hold. So I started thinking about things I could do in order to speed up the case. And I found documentation evidencing who helped Tula, the names of the people, the documentation pertaining to meetings held in Sharjah between the Saudis and the ruler of Sharjah in the Emirates. And I sent all this information through Eldon to the criminal police. I believe it was April 2013, demanding or requesting that they check the correctness of my information, check the documents, check the people behind these companies, because that would hopefully exonerate me from any charges. 1.5 years later, when I'm in court being tried for criminal behavior, the criminal police were asked about these papers that I'd submitted. And they admitted that they'd done nothing with it. They simply put all this evidence in a drawer. Nothing was done to check. And there was no reaction from the judge. My lawyers made many written protests. They asked to have the trial stopped because of this, because there is a duty for the police to look into matters that is in my favor, but they'd done nothing about this evidence, simply put it in a drawer. Now, that wasn't the only thing they did. For 4 years, up until my trial, I requested to get access to the liquidator's documentation in connection with the liquidating process. That is all the files of Thule Drilling, including those pertaining to Ro Sommernes, Henrik Christensen, and these people. Now, according to law, I have a right to look at that. For 4 years, I was denied that right, until suddenly, right before the summer of 2014, only 2 months before my trial, I was told that, what's the problem? You could have looked at these things all the time. Nobody's denied you that. My lawyer said, yes, he has been denied. Olav has asked repeatedly through this office to see these files, the whole files down at the liquidator's office, and he's been denied. So the criminal police said, well, we don't believe that's right, but anyway, you can do it anytime you want. When do you want to come down and look at them? We'll tell Ro Sommernes that he's coming down on such and such date. He'll be given free access to the room, the data room, to look at all the files. So we agreed on the date, next week, and next week came around. And my lawyer calls me and says that he's got word back from the criminal police that they have talked to Ro Sommernes, and Ro Sommernes won't allow it. So I said, well, it can't be up to Ro Sommernes to say that. It has to be the criminal police. If they say that I should have access, if the court says that I should have access, if that is actually my right, according to the law to have access, how can the liquidator say that there is no access? But as it turned out, until this day, I've been denied access. I've never seen those files. I've never seen evidence that probably could have helped me in my case. I've been denied what you call my human rights, according to Article 6 of the Human Rights Convention, to defend myself by being allowed to look at the evidence against me and evidence that can exonerate me. To this day, I have never seen those files. Well, things were about to escalate even further, because in 2014, I learned that the criminal police had taken all my documents, in my case, to Switzerland in order to talk to the prosecution in Switzerland in respect of looking into the accounts belonging to my cooperation partner, Mr. Lecars, an American that helped Tula, and they had actually started a case without my knowledge in Switzerland. So in effect, they were in Switzerland together with the liquidator for the estate. They were sitting down together with the prosecutor in Switzerland, using evidence in my case in order to get the evidence they needed to prosecute me. I had no knowledge of this for 1.5 years. They kept that secret. Luckily, Mr. Lecars finally told me about it. When he told me about it, he said that he had been given an order by the criminal police in Norway, with the agreement, of course, and the support, of course, of the liquidator for the Tula state. They were sitting there together, the police and the ones who had accused me of doing something wrong. They were actually sitting together in the same room, together with the prosecutor in Switzerland, for 1.5 years to be able to find something that they could use against me. Now, the way this turned out is that they have taken evidence that they've chosen very selectively, only evidence that speaks against me. They have manipulated the evidence, and they have used evidence from the process in Switzerland that are clearly falsified evidence. And they have done so without my knowledge, and they have done so based on doing a deal with the Swiss authorities that I would never be allowed to see what had actually happened in Switzerland. In other words, another example of miscarriage of justice as I see it, because how can I defend myself when evidence that are sitting in Switzerland are selected by the criminal police in Norway together with the liquidator for the Tula estate, with the consent of the Swiss prosecution, so that only a small piece of the evidence is being used in my case. Now, why would they do such a thing? Well, as it turns out, the main witnesses from Switzerland, Mr. Olav Eldring and Mr. Claude Tournier and Mr. Rebecca Bodek, who's really just someone who works for Tournier, they had a client list of 200 clients plus, a little more than 200 clients. On this list are about 15 to 20 Norwegian citizens, well known in the financial community in Norway. I have the names of about 7 or 8 of them. They're very well known in the press in Norway. All with anonymous, so-called unnumbered accounts in Swiss banks. In addition to that, there are a lot of American citizens that were also clients of these 2 Swiss, or these 3 Swiss persons, through a company called Profil Guest. Claude Tournier is the owner of that company. Mr. Hans Olav Eldring is part owner and an employee. They ran into trouble because when the criminal police in Norway came to Switzerland trying to frame evidence in my case in order to get me convicted, a larger story came up. That was that Profil Guest had all these clients with unnumbered accounts, with anonymous accounts, and a large portion of these clients were American. At that time, that was a huge problem because, as many people will know, American tax authorities. So what we have done shortly before my trial in October and November 2014, we have a situation where I have then been led to believe that I finally, after 4 years, should be able to look at the liquidator's documentation in order to find evidence pertaining to my case, evidence which would probably also disclose wrongdoings by Mr. Henrik Christensen in that law firm. However, that was denied me. I was led to believe after 4 years that it wouldn't be denied, but they turned around and said, you won't be able to see it anyway. We have a situation in Switzerland where they keep a secret sort of prosecution case going for 1.5 years, where the instruction is not to tell me or my defense attorneys anything about this process, where they're using all the documents in my case to manipulate and select pieces of evidence that they can use against me, together with persons that are trying to hold the lid on a money laundering scheme involving evasion of taxes by American citizens, possibly also Norwegian citizens, and thereby avoiding that the Swiss banking system is confronted with a banking scandal for having had these clients and this tax evasion schemes going through these banks. Now, I can't prove this because I'm not allowed to look at these documents. They have been taken away from my case, which of course is a breach of my human rights, Article 6, to have a proper defense. I cannot have a proper defense if I'm only allowed to see a few selected documents from these processes. That's impossible. So it's a miscarriage of justice. But anyway, my take on this is that there's been a deal between the criminal police in Norway and the Swiss authorities. The Swiss authorities have very strong need to keep a lid on things that reflect badly on the Swiss banking system. And the deal that was done, in my mind at least, is that we'll give you Mr. Olav on a silver platter. We will get Mr. Tournier, Mr. Eldring to file the statements needed against Mr. Olav. We'll prep them. We'll prepare everything beforehand. And after we've prepped them and done everything else, only then will we invite Olav's lawyers to come to Switzerland to also be able to talk to these people and ask them questions. But by then, it'll be a close match. Everything will be ready. There'll be nothing that they can ask that will change the statements that have already been made and fabricated against Mr. Olav. So this is what I believe happened in Switzerland, but I'm not allowed to see anything in Switzerland except the documents that they have picked out against me in order to get me convicted. So I will never know the true story about what's happened in Switzerland. So we have then the case that I'm disallowed evidence that under Article 6 of the Human Rights Convention I'm entitled to see. The court is being made aware of this, but they do nothing. Mr. Elden, my lawyer, tries to stop the whole case. He says we cannot try a case where only portions of the evidence is here. We cannot have a situation where Mr. Olav is asked to prove his innocence, but he's disallowed to use the evidence in order to prove so. That's an impossibility for Mr. Olav. He cannot win the case if he's not allowed to do this. Still, the judge says, let's go ahead and have the trial. Now, next thing that happened was that we were supposed to, before the trial, name witnesses. Now, if you're a defendant in a case and you're charged with a serious crime, you're obviously allowed under the Human Rights Convention to have your witnesses that can reflect on what truly happened in your case. Økokrim, or the criminal police in Norway, they had between 15 and 20 witnesses that they submitted to the courts And the court in Oslo said, yeah, fine, we'll allow that. I submitted between 8 and 10 witnesses that I wanted to have in my case in order to prove my innocence. Among other things, key people down in the Middle East. I wasn't allowed one of them. 0. They would not allow me to call any witnesses. To this day, I have not been able to defend myself by getting any witnesses that could tell the truth about what happened with Tula, who is the true owners of the company that got the 6 million, and so forth. I'm simply denied that. Evidence that I give to them to look into the matter is put in a drawer, allowed by the courts. I'm not allowed to get the witnesses I want. I'm not allowed to look at the liquidator's documentation, because Rosommernes controls that completely. And a secret trial is in effect being held against me in Switzerland, where they select evidence and present to the court. So this is the situation on the first day of my criminal proceedings in Oslo Municipal Court. This is what I'm faced with. This is the obstacles that I have to deal with in trying to defend myself and to prove my innocence. This is what my lawyers call some of the worst violations of human rights that he's ever seen. All these violations have been clearly stated to the courts. They've been explained. No one does anything. So I'm now in a situation where I wasn't even given a half a trial in the first instance. And then when I appeal to the appeals court, they are able to avoid granting me an appeal because the verdict in my case is less than 5 years and you don't get an automatic appeal. So we have instances where people are tried and sentenced to longer and for more serious charges than me, who automatically gets an appeal. And some of these people are acquitted completely in the appeals court. I don't even get to make an appeal. They turn it down. So I have a case that has not been tried properly in the first instant, and I've been denied access to an appeal, which is a violation of Article 6, the right to a fair trial, according to the European Human Rights Convention. And furthermore, it's a violation of United Nations Articles on Political and Social Rights, Article 14/5, that says I have an absolute right to try my case in 2 instances. We have made the court, including the Supreme Court in Norway, aware of all these things, but they simply tell me that I'm disallowed an appeal and they won't give a reason for it. It's simply disallowed. Which leaves me in a situation where I am convicted to stay the next 4 years in prison, and I haven't really had a proper trial yet. I haven't been allowed to submit evidence, denied witnesses. Mr. Lecars, according to the criminal police, was charged with the same offenses or criminal charges as in my case, and that those 2 cases are identical. Now, in order to try Mr. Lecars, they use all of the documents in my case. Mr. Lecars told me that there are at least 20 binders with your stuff in Switzerland. So it's kind of like a circle discussion. And then they use that evidence to come back and try me. Now, they claim that he was tried or he was charged with exactly the same thing that I was. Well, as it turns out, it only turned out to be a money question, because the company where the true owners, the ultimate beneficial owners, are representatives of the Saudi royal family. There is one account that I didn't know of, that Lacarce told me there's $600,000 in this account belonging to the company Strategic Alliance Corporation. And the liquidator for the Tula estate is very eager to get their hands on this money. And in Switzerland, the liquidator for the estate, the criminal police, and the Swiss prosecutors, in every meeting, every conversation they have with the representatives of Mr. Lacarce, and they tell Mr. Lacarce, give us the right to take the money out of that account and give it to the liquidator estate, Ro Sommernes, and we'll let you go. So, concerning charges that supposedly are the same as in my case, it's just a money question when it comes to Lacarce. Give me the money and we'll let you off the hook. Whereas in my case, we want you in jail for 4 years. So what happened with that? Well, Mr. Lacarce did what he was supposed to do. He told him, that's the easy way out. And I'd like to do it, but I can't. It's not my money. It belongs to the Saudi beneficial owners of Strategic Alliance Corporation. I don't have the authority to give you the money. So finally, they just take the money. They take the money, and for the same crime that they allege Mr. Lacarce has done, which was supposed to be exactly the same as I've done, they give him a fine of 10,000 euros, and they ask him to pay the court fees of about 8,000 euros. So for the exact same crime they allege that I have done, for which I should be sentenced to 4 years in jail, they give Lacarce what amounts to a pretty hefty parking ticket, and they let him go, and they just take the money. And then they plant this story in the Swiss press, where they say that the Swiss authorities, together with the criminal police in Norway, has done an excellent job in finding out about criminal activities that has been going on involving Mr. Lacarce, an American citizen, and Norwegian citizen Eirik Olav, which is me, of course. And they say that justice has been done, and the criminal police and everybody has done an excellent job. What they fail to say, of course, is that they put the lid on a large banking scandal in Switzerland involving a few hundred clients that have anonymous accounts, avoiding the IRS, avoiding Norwegian tax authorities, because that was simply the deal that was made. We'll hand you Hans Olav on the silver platter, and we'll keep a lid on all these other things. So that's what happened in Switzerland. But again, how to prove it? Well, I do have evidence regarding American citizens having accounts, because Mr. Lacarce is an American citizen. So I can, and I will, file a whistleblower report to the US Justice Department and to the IRS. Mr. Hans Olav Eldring, who after all these events became an officer of Credit Suisse, one of the banks used by Profilgest in these activities, illegal activities, is charged in London for having defrauded Credit Suisse and others. 5 or 6 plaintiffs have filed lawsuits against Mr. Eldring, who is then the trustworthy witness that the criminal police in Norway use in my case. He's now being chased by Scotland Yard fraud squad for embezzlement and for, taking money away from other decent, honest people who believe in Mr. Eldring. This is the key witness in my case, a person who is now running from the police in Great Britain. And I'm obviously sending these reports to Scotland Yard Fraud Squad. I'm sending it to Switzerland, the equivalent of the criminal police in Norway. Who knows whether they'll do anything about it, or whether they continue to cover up for their own banking system or not. I'm also sending it to the IRS and the US Justice Department in order to do what is right and to exonerate myself finally from these accusations. This will take time. In the meantime, I have to go to jail for something I never did. And I have to do so with the knowledge that there has been a miscarriage of justice, that I haven't been allowed to present my case at all. Now, one of the things that is important to mention here is that this process has now been going on from 2006, 2007, where I worked very hard to try to save value for the shareholders and the bondholders in Tula. And it hasn't gone without consequences for my health, nor my family. From being employed, having a job to go to the past 5 years, I have been taken away my opportunity to work. It's impossible to get a job when you're charged with a criminal offense. We had to move out of our house into a rented apartment, and now we're moving out of that apartment into a very small apartment because we simply have to make ends meet while my wife waits for me outside with my children, wait for me to be released from jail sometime in the future. So this is the situation. I'm going to jail now within the next 3-4 weeks. I'm going to spend the next 3-4 years in jail for something I never did, where people have conspired to make criminal charges stick with me. And all my friends who know this case well and my family are looking at this injustice and simply having to accept the fact that after 4 or 5 years, or exactly now almost 6 years, this injustice does not stop. It doesn't end there. After I've been taking everything from me, job, house, everything, I now have to go and serve 3 to 4 years in jail. By the time I get out, I'll be close to 65 years old. I'll be without a job. Luckily, I have my family who knows I've done nothing wrong. I have 2 children that support their father, of course, and who know that I've always stood for integrity and respectability and always try to do the right thing. So they support me. And my wife also, she's a lawyer. She has looked at my case. She says that she's absolutely shocked at what the system is doing to me. But because she knows I've done nothing wrong, I've always tried to mend things for other people like I did in Tula, that I stepped up to the plate, so to speak, and solved that situation. She knows that I've done nothing wrong, and she's told me if I knew you'd done something wrong, I would have left you a long time ago. So this is the situation that I'm facing. And right now, almost every day I meet with my family. And we do things that we've never done before. We hug each other and we cry and we ask ourselves, when will this end and how will it end? That's the situation.